we have an update that EB-2 priority date for the filing dates have moved 11 months for Indian nationals in the March 2026 visa bulletin. And also, the USCIS said that they're going to accept the filing dates to the adjustment of status applications, which is a very good news for a lot of Indians. As you probably already know, that the priority date has moved to January 1st of 2015 for EB3 and probably November also, November 2014 for the EB2 cases. Now it moved back and it moved forward right now. Even though the filing dates have moved 11 months, the final action dates have not moved significantly. It did move a couple of months, but it did not move significantly though. Emily, where are they coming? Why did they move the priority dates? They have not released the amount of family-based green cards that came into employment base this year. This year means starting October 1st. They haven't. We don't have any inventory right now, is it right? As of this month, what inventory the Indian nationals EB2, EB3 are pending?
No, we only have from October 2025 at this point.
Okay, and what do you expect, Emily? Though next year, that is fiscal year 2027, which starts on October 1st of 2026. Since the 70 country restrictions where they cannot get the green card if they are in United States, and if they're in United States, they cannot get the green card right now. And also the family-based green cards are restricted. Could this 70 countries ban, because they are not giving green cards for these 70 countries? Could there be a good number of green cards given to Indian nationals because the backlog is significant for Indian nationals?
Yeah, I do think there's a good chance for a large number of spillover from family-based into employment-based for 2027, which would start from October 2026. Based on the numbers, looking at that 75 country ban list, in the past, how many green cards went to those particular countries in the family-based category? Somewhere around 50,000, we'll give it that round number. And so if those green cards go unused because they cannot receive the green card because of the ban, then those will spill over to employment based. Now, those 50,000 are going to be divided up between EB1, EB2, EB3, just like they normally are. So you get 28% to EB1, 28% to EB2. And then within that, the numbers that are not used by the rest of the world will go to the countries with the most backlog, the furthest back priority date, which is generally going to be India and maybe to some extent China. So I do think we'll see some movement in October 2026. Maybe that's why they moved the filing date now in March 2026, so that people who have not yet filed can get their applications in, and then USCIS will be ready to approve them in October when the date moves. Maybe, hopefully, they were thinking ahead on that part. But just looking at these numbers, so we do have, as I mentioned, the I-485 inventory that tells us how many EB2 and EB3 485s are already pending with USCIS, listed out by their month and year of their priority date. And so as of October, there were about 43,000, which is a pretty big number given the number of 485s that can be normally approved in the EB2 and EB3 category for India. We still don't know how many green cards went to the various countries last year. As far as I know, that statistical data has not been published yet. It does get published every year. So I'm basing my estimates on the 485 inventory itself. We have the inventory from October 2024, and we have the inventory from October 2025. In October 2024, there were about 50,000 485s pending for EB2 and EB3 India. By October 2025, 1 year later, there were about 43,000 pending. So about 7,500 were able to be adjudicated in that 1 year span. I think that that's a pretty steady number, a pretty stable number to use as maybe a estimate. Obviously, these numbers are 3 months old. So if we're thinking 7,500 a year, in one quarter, they should have adjudicated 1,800 so far. So there's still 41,000 people left in that right now for the rest of this fiscal year, is my guess.
Emily, you are saying that 7,000 were been adjudicated in the last year from starting from October 1st to September 30th. But there are some people who have already filed in EB-2 and EB-3. Even though the date has not crossed January 1st of 2015, there are some leftover people. I do file the adjustment of status. There are some extra filings that were being done. So I believe that more than 7,000 people would have got the green card in the EB-2 and EB-3 Indian nationals in the fiscal year of 2026, which starts in October 1st of in the fiscal year 2025. It starts no 25, 26. I forgot it. Which starts in September 30th, 2024 to October 1st of 2024 to September 30th of 2025. That's being said, though, do you know how many people were been given the green cards from these 70 countries in the fiscal year 2024 or 23? Do we have any figures? Because right now, the USCIS is not approving their green cards if they belong to these 70 countries. They're just putting a hold on those cases. They're not approving anything. So there may be a chance that these 70 country green cards, which were going to those people, would be coming to India. And there are some extra 25,000 green cards, I'm assuming, that came from family immigration to the employment-based immigration, because the previous year they published it, this year they did not publish it. But I'm assuming at least 25,000 would have come in. That could be the reason why they moved the dates. Also, since the 70 country ban is there, not only that their employment-based immigration will come to mostly to Indian nationals or to the Chinese national to some extent, but the family-based immigration that we're supposed to go to these 70 countries, the spillover will come to the employment-based. Eventually, Indians will be the most benefactor persons in the employment-based because of the 70 country ban.
Yeah, so with the 70 country ban, we do have the data going back year by year, the list of every single country, how many family-based green cards they received every year. On average, if you total all of those up, it comes to about 50,000. So that's kind of our ballpark figure of assuming that would have been the same this year. Maybe those 50,000 are not going to end up being used by the other countries that are not on the ban because they don't have enough applications already in the pipeline to process them quickly enough. Those consulates are already, using all of their resources. So how can they adjudicate more cases for the countries that are not subject to the ban? So if that happens, those green cards end up being wasted for family-based, but then spill over to employment-based for the following year. Other things to look at, if we're looking at the current visa bulletin and the final action dates, in the 485 inventory that we have from October, EB-2 still has about 4,500 485s pending with a priority date before July 2013, which is the current cutoff date. And EB-3 has about 2,400 pending that are actually current right now before November 2013. So that comes out to 6,800. Again, if we assume that 1,800 were already adjudicated in the first quarter of the year, that still leaves about 5,000 available in the inventory that could be adjudicated that are already current under the final action date chart in the month of February. Now, if we move from the final action dates of February to the filing dates in March. So for EB-2, that's going from July 2013 to November 2014. EB-3, that's going from November 2013 to August 2014. How many 485s are in that range? It is about 28,000. that are already pending. Now, again, as you mentioned, some of those might be both EB2 and EB3, so it's double. We don't know how many that is. But 28,000 is a pretty large number to get through. I'm not sure where they're getting that number from to have that many available visas, unless there was more spillover in 2026, our current year, that we're not aware of because we don't know how much spillover there is from last year, or they're just preparing for that extra family-based spillover so that they'll have the cases in the pipeline to be able to adjudicate in October if we see a jump in the dates at that point.
But overall, Emily, I believe that the priority date is going to advance in October, as you said, is right, Emily? In October of 2026 is where we are expecting the priority date to advance.
Mhm.
We were previously estimating that it could not have moved beyond January 1st of 2015, but because the 70-country ban came in right now, not only that, what the 70 countries could have eaten the employment based would be coming to Indians. Most of them would be coming to Indians. And also the family based spillover, most of them will be coming over to the Indian nationals. So the priority date could be moving way beyond January of 2015 at this point of time, is my estimate. At least the filing dates is what I'm estimating in October.
Yeah, so if you think that 50,000 is going to be spilled over, 28% of that goes to EB2, 28% of that goes to EB3. That's 28,000 green cards right there. How
Yeah.
many were between the filing date and the final action date? I just said 28,000.
Right. I mean, you said 28,000. If there 50,000 is going to be falling into the into the employment-based category, 28% of that will be actually 14,000. Yeah, you're right. 14%, 14 for EB2 and 14,000 for the EB3. That's 28,000 will go to. That will, yeah, that's probably the reason. Not only that, Emily, I'm thinking of that some of the employment-based immigration are used up by these 70 countries. Do we have any data on that? How much?
We do, and I don't have it because I didn't think to look at that.
Okay. Okay. No problem.
But
So,
yeah,
so
in the rest
yeah,
of world, yeah, some of those employment based will have
employment based
more
will be
spill across
right.
than we
Will be
normally would.
word. So most probably these people who are before January 1st of 2015 will be done with. And in October of 2015, we may see some good advances. So there are questions coming on that is my priority date is going to be current if mine is January 2015, October 2015, definitely, most probably it may become current next year. That is our estimation. Um, uh, uh, People are asking questions. Blue is asking question from YouTube. What if does the 7% rule apply for the spillover numbers? Yes and no. Here is the thing though. If the 7% is still applicable for the spillover, it is applicable. However, when the rest of the world does not use their thing, I mean, if it's current in the rest of the world, or if they don't use those things, all of them will come to India. So when I look into the visa bulletin, though, practically the way I look into is that it's October. Practically, I look is that October 2024 is the priority date for the EB2 final action date for the rest of the world. I mean, think of this one. Labor certifications are taking a long time right now. So most probably they are very current for the EB2 and EB3. There may be the rest of the world may not be using the things. So whatever the rest of the world doesn't use, India will get it. India will get 7% of everything. India will get 7% of the spillover, but India will also get the ones that are not used by the other country. So definitely overall, Indians will be beneficial with the 70 country ban, and not only and also spillover. Also, Indians will be beneficial. But will every green card that is spillover will come to Indians? Maybe not.
Also from Facebook, the question is, what about EB1? Is there any likely movement in the coming months there? So, if we think about, again, October 2026 being when we can see that spillover from unused family-based due to the 75 country ban, again, EB1 is going to get 28% of those 50,000. Again, 50,000 is our guess. So that's 14,000 extra to EB1. Well, guess what? In all of the years, the last 20 years, generally EB1 India gets about 10,000 because they get the spillover from rest of world there. So yeah, we should see quite a bit of movement in EB1 to where an entire year's worth of green cards become available to them on October 1st extra from what they already get.
People are asking question. My prior date is 2017, India. Should I ask my employer to file the labor certification? Yeah, definitely yes. Definitely yes. And if some people are contemplating on moving the jobs right now, if the priority date is close by, definitely I want you to evaluate yourself before you move to a new company, because the labor certification is taking a long time to get it, though. Almost 2 years to get the labor certification. So if you move in and you are in transition, the priority date becomes current, you may not be able to file the 485 application.
Yeah, and so for people that are priority dates after January 2015, that's where it becomes much more difficult to try to predict because there is no 485 inventory for people after that date because no one has ever been able to file. So because there's no inventory, we don't know how many people are in line from January 2015 to January 2016 to know how many cases they have to get through. And then in terms of final action dates, kind of why those didn't move, again, looking at that inventory, people that already have a current final action date in EB2 and EB3, I'm guessing it's around 5,000 that are still there, assuming that they adjudicated about 1,800 in the first quarter. And so that's why they're not able to move that because they already have enough 485s pending to be able to use up the remainder of this year's visas. Again, assuming 7,500, that's based on how many 485s got adjudicated last year. Again, we don't know what the difference in spillover is for this year compared to last year. There was spillover last year. There probably is this year, but we don't know the number. And then rest of world also makes a big impact because you'll see in the filing date chart for March that EB2 rest of world becomes current. And as Raul said, those people, they would have had to have started the labor certification already to be able to use those green cards that are becoming available when it's current. And so when those don't get used, they spill across to India as well.
People are asking question. I think so. He's asking question. Anita Bandar is asking: does it affect the marriage-based green card? My daughter recently filed. I don't know what do you mean by marriage-based green card, though. A marriage-based green card definitely falls into the family-based immigration. And if a person is married to the U.S. citizen, they don't fall into any category. There is no F1, F2, F3, there is no category. They just are immediate relatives. They don't come in any category. And there is no priority date. They're always current.
Aparajit says, my priority date is September 2016, planning to pursue the EB1A route. Should I still pursue that or wait for EB2 to become current? I mean, with EB1, obviously that would be current for you today. Because you get to port your old priority date. I think there's still going to be a long wait for September 2016, even with this spillover. Again, we don't know, but we can only assume that every year after 2015, there is a large number of people that have approved I-140s and are waiting in EB2 and EB3. We do have some data that I looked at quite a while ago. I'd have to see if it's been updated. They do normally come out once a quarter with the number of approved I-140s who are waiting priority date by country and by category. So we can look at that and see, okay, how many are there? And if we're assuming they can use 7,000, 7,500 a year, that would give you an idea of how long it might take to get to September 2016. But in my mind, yeah, I would go with EB1A because there's still a lot of uncertainty, and I think there's still going to be some waiting even beyond October 2026.
Ethic Tech has this question. My priority is November 2015, EB to India. Shall I change my job or wait few more months to see how date progresses? If I'm you, I will not change the job. Now, I'm not telling what to do because I don't know. Sometimes these dates I cannot predict it properly. But if I were you, I would not change the job. That's one of the reasons why we wanted to present this one. What precautionary steps that you can take? For example, I would not leave the job if I were you. And if you're working for a company and your priority date is in 2015, 2016, somewhere around that period of time, yeah, it is right time for you to apply for the green card. If your current company has not applied, I definitely would like you to stress to apply for the green card.
Kind of along those lines, Arjun says, if my date became current and my current employer has not gotten the I-140 approved yet, can I move back to the old employer when it becomes current? Yeah, I mean, assuming that that job is still available and the same terms and conditions, and the employer is willing to sign the supplement J form, that is an option. A lot of people definitely did that in October 2020. So we've been through this before, where we had a big jump in dates and it caught a lot of people off guard because they didn't have their perm in place or their I-140 in place with their current employer. So they had to wait 2 years, and then dates retrogressed, and then it took forever to be able to file, or they went back to the old company in order to be able to file. So that is an option if that job is still available and the company is cooperative with signing the supplement J form.
Suppose it's stuck in India on H1B, but the priority date became current, how to proceed further? It depends on who is the primary applicant. If you're the primary applicant, your spouse is stuck outside the country, you will have to take a decision whether you want to file the 485 with the spouse or by alone. If you're the primary applicant, I normally would recommend that you file it without the spouse, and you can have that person following to join, or whenever the person gets into the country, if the prior date is current, they can be added to this application. But there are some minus points. If you get the green card, the dependent may not get the green card along with you. So we have to look into. I mean, you have to evaluate when the date becomes current whether you want to file it or you don't want to file it.
Prashita says, my priority date is December 2014. Do you think it will become current in the next 4 to 6 months? I'm assuming this is in EB2 or EB3. Obviously, with the filing date moving to November 2014 for EB2, that would suggest that that November 2014 date might be current by the end of this fiscal year, September 2026. So if you're December 2014, then I would say no, that does not seem to be likely that it would be current in the next 4 to 6 months, but maybe in October when we see a big jump there from the spillover that we're anticipating.
Raji Guruswamy has this question. I have a 485 pending and my priority date is November 2014. What can I change the job? Is it risky? No, I don't see any problem. Your 485 is already pending. I'm assuming that it's been pending for more than 180 days. If that is the case, it's pretty safe to move to a different job as long as the new job is in the similar lines of your current job. I don't see any problem with it. It's only for those people where they have not filed a 485 application, the date is about to become current. I definitely, if I were them, I would not move out of the job.
Harry says, so many people are still waiting from June and July 2013. Cases have been pending for 5 years. What's the benefit if they're not approving from 2013, but they're moving the dates deep into 2014? Yeah, that's a really good point. But at the same time, the date that they're moving is the filing date, obviously not the final action date. So the filing date generally is to allow USCIS to get enough people in the pipeline so that they can be ready to adjudicate by the time the final action date becomes current. Now, obviously, since we're not moving beyond January 2015, we're not going to get a ton of new applications during that time based on the filing date chart. It's going to be people that missed the boat previously because they didn't have the labor certification with the current company, people that got married since then and are now adding in their dependents and that sort of thing. So the number of new filings, I think, is going to be quite low. And so they're just making sure that they have enough in the pipeline to use up all of the green cards this year by September 30th.
Asking question with the, do you know how many family-based petitions were being spilled over from fiscal year 2025 to 2026 for employment-based? No, we don't have that exact number. The previous year, it was about 25,000, but in the fiscal year 2025 to 2026, they did not publish the record though. Vineet Gupta has this question, will there be still a big jump in October 2026 visa bulletin? We know that there will be a jump. Whether there is going to be a big jump, I cannot tell it. But we are expecting a jump in the visa bulletin in October 2026. We are expecting a jump. Now, whether it's going to be a huge jump, we don't know, but we are expecting a jump for sure.
Prabhu says mid-November 2014 EB-2 case pending, anything to be done when it's current. So of course, it's not current under the final action date chart. It's only current under the filing chart. So there's nothing to do from that standpoint. But when your final action date does become current, look into, or shortly before that, look into your medicals to see if those expired. You could consider doing new medicals and submitting those through an interfile request to get the case moving, to get their attention, and also so that you don't have to delay by getting a request for evidence. Using a supplement J can also be helpful for that too. If you've changed jobs and have a supplement J to submit, doing that when the final action date is current can also be helpful. And of course, with these dates moving forward and backward between EB-2 and EB-3, only when your final action date is current in the different categories when you want to do that transfer of underlying basis if you have multiple I-140s approved in both categories, making sure that you're aware of how that changes things for the Child Status Protection Act. It's possible that your kid's age might be locked in one category but not the other. So you want to make sure that you look into that before you decide to do a transfer of underlying basis.
Ramcharan has a very interesting question. His prior date is 2016. If he changed the location with the same employer, does he need to file a perm labor again? Can he use the same I-140 to file the 485? I would definitely say that if it's a consulting company, though, definitely they would have documented it in such way that you could be working for any unanticipated location. So you should be fine if it's a consulting company. If it's a full-time company, though, I definitely want you to consult a private immigration lawyer to evaluate how to ask the questions, because there are ways where the company don't have to file the labor certification. For example, if the labor certification has been filed for a full-time company in San Jose, California, and now you're working in Texas. Now, if you're going to approach the company, then they may say they want to file the labor certification, but there are ways. If you would approach the company saying that I intend to move back to San Jose, California, once the green card is approved, then if the company accepts it, then there is no need for them to file a perm labor certification. So definitely it's a way to approach. It's a way to approach how the company does it. If the job at the final, once you get the green card, you're going to work in San Jose, California, then definitely no labor certification is required. What we see with the FANG companies like Meta, Apple, and other companies, they normally don't file a labor certification again and I-140 again, but they normally ask the employee to sign a document that once the green card has been given, they will intend to move to the particular location they filed the labor certification. So it's better that you consult an outside lawyer before you speak with the company HR.
Whatever says my priority date is October 2013. Should I downgrade to EB-3 or wait for EB-2 to become current? Well, with October 2013, obviously right now you are current in EB-3 under the final action date chart. We would expect, based on the
Some interruption going on from Emily. The question is coming with regards to, does the filing the 485 application locks the kid's age? In the recent development, though, only final action date will lock the age. The filing date does not lock the age. Previously in the Biden administration, I think so it's until like about Biden administration, it did lock, but recently they changed the law with regards to filing. Filing does not lock the age of the kid. I'm sorry, I took over, Emily. You want to
Oh,
finish
that's
it,
fine.
please?
Yeah, I don't know what happened there. So yeah, with doing a downgrade or not. So it seems to be possible that your date might become current by September, October in EB2. So you're gaining maybe a few months by doing a downgrade and getting the adjudication now in EB3. Is that worth doing a downgrade? Maybe not. I think it would partly depend on the strength of the case. What do the company's tax returns look like? Have you been with the company the whole time so that they have the ability to pay covered? And then another thing to think about is when we do see these big jumps, looking back to October 2020, assuming we see a repeat of that in October 2026, it was a mad rush to file. It took October, November, December, January, 4 months for us to get receipt notices for the filings that were done in October 2020. And so if you want to avoid that kind of mess, maybe downgrade might be a good option. It really just depends on how important.
Sorry for the interruption. There are some people who are asking questions with regards if the priority date is getting nearby. Should I file the EB1 application, EB1A application though? I would definitely do that. I mean, you can't guarantee that the priority date is going to be current. So I would definitely will file the EB1A application. But when it comes to the EB5 kind of thing, there's a lot of money involved in it. I'm going to evaluate myself whether it's worth for me to go forward or not. But when it comes to EB1A or those kind of things, EB1B, I am willing to go forward. Emily, anything else?
RC says, did USCIS plan to use the unused rest of world visas from the current fiscal year and advance the dates based on that? Or is it because there was spillover from 2025 to 2026? I mean, we don't know. I think that typically we do see in the spring some forward movement of the filing date chart so that USCIS can have enough 485s in the inventory to be able to adjudicate in that fourth quarter when we tend to get the rest of world extra green cards to India. So I do think that is a possibility, but just based on how far forward they went, my guess is it's based on their projection of spillover too, and they're just preparing for that. I hope that's what it is. I hope they're not too far off on their predictions here.
I definitely feel, Emily, that they're going to use up the 140,000 and the spillover will be because I've seen a lot of adjudication done in the 485 in the past 3 4 months. I've seen a lot of these cases getting adjudicated though, so there hasn't been any slowdown in the 485 applications, and especially in the EB1 cases where we have filed applications, they're getting adjudicated in 2 to 3 months though. So definitely they're doing very good job in adjudicating. Now there are some people who have been waiting for a long period of time to get the green card, so they are stuck there because either their medicals have expired or the file is sleeping. You have to wake it up, especially when the priority date is current though. You should contact your immigration lawyer to ask what should I do to get my date to get my green card.
All right. Anything else?
No, Emily, we're having some technical issues. Thank you.
No problem. Thanks.